Started today, so today's training session is on the area of personal injuries litigation and medical negligence. So I'm going to look at them separately because medical negligence is quite a specialised area in itself, and it's something that you may come across as a distinct query that comes up in the clinic. So first of all, has anyone taken TORT already? Are you familiar with negligence, medical negligence? Is everybody vaguely familiar? Yeah? So if you have any questions throughout, just please feel free to ask me if some terms are unusual to you or if you don't understand. So the first thing I want to talk about and mention, and it's something very practical that you have to be aware of with any client that comes in and has a personal injuries type of an action, is to be aware of the statute of limitations, okay? And basically this is the time within which an injured party can issue proceedings. And with most personal injuries actions, it's going to be 2 years, okay? So it's going to be 2 years from the date of knowledge, right? Now, just to point out that this is generally deemed to be 2 days from the date at which the cause of action took place, okay? So the date of the accident. However, the date of knowledge might also be after the cause of action. Okay, so for example, this is often typical with medical negligence cases. If somebody has an operation and the operation takes place in January and the operation was carried out negligently, and say the doctor or whoever left a needle or left a pair of scissors in the patient, they may not realise until 6 months later, 3 months later, that there's actually been an injury. Okay, so the date of the time starts to run on the date of knowledge. Okay. Also to note another exception, and that is in relation to minors, okay? So minors, the date begins to run on the 18th birthday, okay? So it's 2 years after the 18th birthday. However, just to point out that proceedings can be initiated within the first 18 years through the procedure known as the next friend, okay? So somebody, for example, a parent, can issue proceedings, can sue on behalf of the child. But just to point out here that, if you are going to wait until the 18th birthday and you have your 2 years which starts to run then, just to be aware that, evidence may be destroyed, memories start to fade over that time period. So it may be preferable to advise a client or to give information to the client in relation to the next friend procedure, because it may be the most practical means of initiating the case. Okay, so what types of accidents may you be presented with? So you have road traffic accidents, okay, which are fairly common. You have work-related accidents, okay, in connection with employment, and you also have public liability accidents, okay. So that might be a shop that there's a spillage in a shop. You may have a curb whereby a person trips and falls over that. So you have public liability actions. In looking at a case and looking at proceeding in these types of cases, there are 2 essential elements that you must be aware of. First of all is liability, okay, and liability is effectively legal fraud. And secondly is the injuries, okay. You must obviously show that there is actual loss or damage. And both of these components are going to be necessary in order to succeed in a case. So in looking at liability, you obviously must prove that there has been negligence, that there's been some form of a breach of duty, and that could be a breach of a common law duty, or it could be a breach of a statutory duty. Okay, so for example, in employment, employers have a common law duty of care to employees to, for example, provide a safe place of work, to provide a safe system of work. They also have various statutory duties to the employee, for example, under health and safety legislation. So liability obviously is key. So establishing liability, how in practical terms are you going to establish liability? So a number of elements are necessary. In some cases there are going to be independent witnesses, okay, so if you have a road traffic accident, there may be witnesses. If it's an employment related matter, you may have other employees who may have witnessed what had happened. The Gardaí are often key in these matters. For example, with road traffic accidents, the Gardaí will obviously, they'll have a report, there'll be a sketch of the incident, and there'll be various statements made. Okay, so these are all key elements in terms of establishing liability. Photographs, engineers' reports and other expert reports. So for example, medical reports, in medical negligence cases, medical reports are going to be key. And it's obviously important to get an independent medical report in order to establish liability. Evidence of damage is obviously going to be key. So, for example, if you have a road traffic accident, damage to a car, okay, or with a medical negligence case, if you have, for example, negligence in relation to a faulty implant, okay, so you could have a faulty hip implant. That faulty hip is going to be evidence of the damage, okay, so that's all evidence that's going to be gathered in putting together the case. What's really important as well from a practical perspective, and again this is more so in practice, this is what the solicitor is going to be concerned with, is to identify the correct defendant, okay? Because the defendant is going to be listed on the legal documents that are going to be lodged in the court, okay? So it's really important if you have a case against somebody that you name the correct defendant. And this is why it's important to kind of ask all of the relevant questions of the client who comes in to ascertain what exactly happened, who exactly is liable. So with the road traffic accident, you're going to have the driver or the owner. With work accidents, and this is a tricky one. With work accidents, if you have a company, okay, there could also be a parent company, okay. So it's important to try to ascertain what is the exact name. Are they trading as? Are they a certain company that are trading as something else? Something that I found quite useful when I was training in terms of finding out the correct defendant is you can go onto the company's registration office, okay, so it's the CRO website, and you can access a huge amount of information on registered companies, okay, so they will have the correct title, or they should have the correct title, and you should really try and get that right, obviously in terms of lodging the documents in court. But that's not something that I get too bogged down with now, because for the purposes of this clinic you're not going to be filing documents, but just to be aware of it from the client's perspective. In terms of public liability, again, just to be careful with the company, be careful with the correct name or title to put down. County councils can quite often be the correct defendant if you have a slip and fall incident with a curb. It could very well be the county council that's liable. Something also relevant to note is that there could well be multiple defendants, okay? There could be various different parties who are concurrently liable, okay? So you have concurrent wrongdoers. So just for example, if you have a medical negligence case, you may be suing the doctor who allegedly carried out the faulty operation, or who failed to diagnose, or whatever it was, and you might also be suing the hospital, because they may, for example, not have put in place the correct procedures for training. They may not be providing a safe place of work. So just be aware that there can be several people listed on the court pleadings. So injuries, okay? What type of injuries are there? So obviously it's essential to kind of prove that there has been loss or damage. First of all, you can have physical injuries, okay? So this would encompass soft tissue damage, broken bones, dental injuries, you could have amputations, you could have spinal cord injuries, brain injuries, catastrophic injuries. In addition to physical injuries, you can also have psychological injuries, post-traumatic stress disorder, depression. So all of these can be deemed to be injuries or loss for the purposes of personal injuries actions. Also, just to be aware, and again, this is what this list will delve into in more detail, is to be aware of pre-existing injuries. Okay, is everyone familiar with the eggshell skull rule? Have you covered that? Also to note intervening causes. Okay, what was the actual cause of the injury? Okay, so is everyone okay so far? Yeah. Okay, so just to kind of get into the procedural steps that are taken in a personal injuries action. Okay, and this is divided up into 3 different elements. Okay, so first of all, before anything happens, when you go to your solicitor, you may have a client who says, I want to sue, I want to, what can I get, how can I win this? The first thing that a solicitor should do and should explain to the client is that it's necessary to send what's known as a letter before action or a letter of claim. Okay, so they're two different terms. And basically what this is it's an initial letter that's sent to the client. It's setting out, it's sent to the other side, and it sets out the details of the alleged incident. It sets out the date, the various different elements of the accident, what the loss or damage is that is claimed, if there's compensation, how is this calculated, and you may have various other documents that could be annexed to that letter. But basically, this is a letter, an initial letter, notifying the other side that there's a claim, and also calling upon the other side to admit liability and to settle the action. Okay? So quite often, we try to be practical here. If you're a solicitor, you try to give the client the best possible outcome. Going to court is obviously going to be time-consuming, costly. There's a huge lack of resources. It's a difficult process. So it's always preferable to look at the means of settling an action in advance of going to court. Okay? And indeed, if the case does go to court, the judge will most likely say, where's the letter of claim? Where were the initial steps taken in order to wrap this up or to try to resolve the matter? Okay, so that's sent. That's the first step. Secondly, with personal injuries in Ireland, okay, it's necessary that prior to going to court, that you take the case to the Injuries Board. Okay, so the Injuries Board, it was established in 2004. Okay, and at that time it was known as the Personal Injuries Assessment Board. Okay, is anyone familiar with that? Yeah, you might have heard of it. So the basic idea behind this is to speed up the process of dealing with claims, to deal with them in a more timely manner, in a less expensive manner, and to try to avoid the hassle, the cost, etc. of going to court. Okay? So after that, and I'll go through in detail, what is required of the Injuries Board and the steps that need to be taken. And then the third step, obviously the last resort, should be court proceedings. Okay, so you issue then the summons and the case proceeds. So first of all, as I said, the letter before action, it's the initial step that's taken in these cases. And it's advisable that the letter before action is taken within 2 months or as soon as reasonably practicable. Okay? And also just to note that the letter before action is actually a statutory requirement. Okay? Section 8 of the Civil Liability and Courts Act 2004, this makes provision for the letter before action. So it's actually the solicitor, if they're doing their job correctly, this is the first step they should take. So, and again, you set out the details of the allegation, the type of accident, the cause of action, the compensation, etc. Okay? So, in going to if that doesn't work, okay, which obviously a lot of defendants may just simply ignore the letter. If that doesn't work, you go to the Injuries Board. Okay? So, this is, it's very procedural, okay? And if you go onto the Injuries Board website, which is www.injuries.ie, you will see the various steps that are necessary. So, first of all, there's an application form, which is Form A. You just fill out the details. The solicitor, it's advisable, obviously, that a solicitor would help, fill this out on behalf of the client. The details of the accident and all anything that's relevant to the claim. Form B is a medical report, okay, obviously setting out the loss, damage, etc. Also the client's authority, and a letter from the client to the Injuries Board, okay. And there is an application fee with this process, and it's €45, okay. So you can see that it is quite economical. The idea there is to get cases in and out quite quickly. So what happens then is that a notification of the claim is then sent to the other side. Okay, so it's sent to the respondent, and they have 90 days within which to accept or to decline. Okay, so what happens here is that if the respondent decides to accept liability, the Injuries Board will then assess the claim, and they can only assess the claim if the respondent has decided or agreed to engage in this procedure. Okay, if they disagree, okay, the Injuries Board will then make an authorization to proceed to court. Okay, so the Injuries Board will either assess the claim or issue the authorization. In making their assessment, okay, so during this procedure they have 9 months to make their assessment. They look at what's known as the Book of Quantum. Okay, so the Book of Quantum sets out the detail in relation to the compensation for the particular injuries. Okay, so it breaks it down into quite a bit of detail. You know, if you've a broken leg, if you've a broken arm, this is what the advised compensation is. If you have suffered an amputation of, you know, one arm, two arm, you know, whatever it is, it will set out a particular amount. So the injuries board will follow this book of quantum. And then, as I said, if they don't assess the claim, they will make an authorization to go to court.
Can I ask, this €45 is refundable or not?
No, it's not. No. Yeah, but it's a very nominal fee now in comparison to legal fees. If you're going out to court, it will be worth thousands most likely. So it's a very economical fee. So does anyone have any other questions on that? Yeah. Well, I advise you to have a look at the Injuries Board website. Just have a look at the forms, have a look at the steps that are needed, and just to become kind of familiar with what is involved. So again, it's really important, obviously, to bear in mind time. Okay, so to bear statute in mind. And as I mentioned, it's generally 2 years from the date of accident or 2 years from the knowledge of the incident. What's important here with the Injuries Board is that time is actually stopped on the date that the Injuries Board acknowledge receipt of the completed application. Okay, so that effectively stops. And as I mentioned, when the Injuries Board are making their assessment, they have 9 months within which to make this assessment. Okay? So obviously the time is stopped from that period. If the Injuries Board make an authorization, okay, so that you can proceed to court, the time is then stopped for a further 6 months after they make that authorization. Okay? So I have an example here, and you can I won't go into too much detail. You can read this on the notes yourself, but it's just to kind of be aware that it's really important to acknowledge the time restraints. And I know 2 years might seem like a lot of time, but when you're gathering evidence, when you're looking for medical reports, when you're gathering, you know, the relevant documentation, it's actually not that long really. So you do need to kind of proceed as quickly as possible. So if somebody came into the clinic and you might ask them about dates and get as much information as you can. If the accident happened, say, 6 months ago or a year ago, you would advise them, obviously, depending on the merits of the case, to engage a solicitor, to go to a solicitor as quickly as possible, to get the required advice on this and to go through the Injuries Board, to go through the various different steps. Okay? So anyway, if the Injuries Board doesn't proceed, we're moving on then to court proceedings. Okay? And in terms of jurisdiction, okay, so what court will you go to? You have obviously the Circuit Court, first of all. And just to note that previously the Circuit Court heard claims up to just over 38,000. Okay. Now recently, just this year, there have been changes in relation to the jurisdiction of the Circuit Court, and the new monetary jurisdiction is now up to €60,000. Okay, which is quite a jump. Now, obviously, the thinking or the logic behind this is to make it more accessible, to expand the resources open to those who have claims in excess of €38,000. Okay, because previously you'd have to go to the High Court. There's a huge backlog of cases in the High Court. It's more expensive. You may be talking about engaging further, you know, barristers, etc. So that's a new development in the Circuit Court. Okay, so what happens when you're issuing proceedings? Okay, and this is very, very procedural. And a lot of this is dictated by, you have the Circuit Court rules, okay, and you also have the High Court rules. So they have various different steps and they have various different templates for drafting these pleadings. Okay, so when the client goes to the solicitor, okay, depending on the nature of the action, depending on the claim, they will generally engage a junior counsel. Okay, so you have junior counsel and senior counsel. They generally, at an initial stage, engage a junior counsel. Okay. Now, quite often the solicitor, if it's a small claim, they would draft the proceedings themselves. But for the most part, it would be junior counsel who would be drafting the proceedings. If you're taking the case in the Circuit Court, you must lodge what's known as a personal injuries civil bill. Okay, so this sets out the detail of the personal injuries action. If you're taking the case in the High Court, okay, it is a slightly different name. It's a personal injuries summons. Okay, and again, there are templates, and these will be drafted depending on the level of detail, depending on the complexity. These will be drafted by the junior counsel. So, and again, when you're issuing proceedings, just to be careful and be aware of the time. So the first thing that happens is that the civil bill or the personal injury summons, it's going to be drafted and lodged in the court. Okay? So what do you think the next thing that happens then?
Response.
Yeah, so you have to send it to the other side. Okay, so the solicitor will lodge the documents in the High Court. Okay, they'll copy the client. Okay, so the client must have a mirror image, obviously, of the file. It's important for the client to be kept up to date. And also, the respondent, of course, needs to be in receipt of the civil bill or the personal injury summons. So they'll send it over to the other side. So then, the next step is for the defendant, okay, to issue and to lodge what's known as an appearance. Okay, so the appearance, which generally should be lodged within a 10-day limit, the appearance basically is an acknowledgement by the defendant of the claim. Okay, so it's an intention to defend the claim. And again, this is lodged in the court. Two further documents may be exchanged between the parties, okay, and this isn't absolutely necessary, but depending on, again, the complexity of the case, depending on the particular circumstances, we have what is known as a notice for particulars, okay. So a notice for particulars is basically a request for further information, okay. So for example, you could have the defendant who has just received the civil bill, they've entered their appearance, they obviously want to defend this case, okay, but they need as much information as possible in order to draft up their defence. Okay? So for example, you could have you could have a road traffic accident. Okay? And the defendant may want to know, for purposes of the defence, was the plaintiff wearing a seatbelt? Okay? So they'll have all of this detail in the notice for particulars, and they'll send it to the other side. Okay? So they'll send it to the solicitor for the plaintiff. Okay? Then what happens is the solicitor for the plaintiff will then issue a reply to the particulars. So they'll respond, okay? And this document, it could be 5 pages long, it could be 50 pages long, okay? So again, depending on the complexity of the case. So at that stage then, obviously, it's up to the respondent to issue and to lodge their defence, okay? So again, depending on the subject matter, depending on the complexity of the action, they will draw up their defence. Also to note that there is, depending again on the details, the potential to lodge a counterclaim. Okay, so the defendant may wish to lodge a counterclaim. Okay, so then the final document is the notice of trial. Okay, so when the case comes around, it's obviously important to send the notice of trial to the respondent. Now, I wouldn't get too worried about this. You're perhaps not going to explain this level of detail to a client who comes into the clinic, okay? But just to be aware for yourself on the various procedures, you know, it is quite lengthy. There's a lot of toing and froing back and forth. Does anyone have any questions?
Oh, because I'm not familiar with your legal system, the solicitor and the barrister, what's the difference? The circular court and the high court, who can present the client?
Yeah, okay, so the solicitor and barrister. In Ireland you have two systems, okay, so you have a solicitor and you have a barrister. The solicitor is the first port of call for the client. You initially go to the solicitor. The solicitor will do a lot of the paperwork. They'll advise the client on the merits of their case, and they'll give as much advice as possible. It is then for the solicitor to engage a barrister. Okay, so the barrister would represent the client in court proceedings.
Oh, solicitor couldn't go to the circulate.
The circuit court. Well, they can, but again, it's typical for the barrister to represent in court. Okay, and if you have a particularly complex case, okay, you may wish to engage a senior counsel, okay, who is an expert in a particular area, and they will draft up an opinion to give to the solicitor. But it's two different roles. Yeah.
Here I want to know. You just said there are 3 types of accidents here. And which accident it takes frequently? It's a road traffic accident, work-related accident, or public level accident?
Yeah.
Which accidents happens frequently? More times?
More frequently?
Yeah, yes, more frequently.
Oh, I mean, it completely depends. There's a lot of road traffic accidents. That is quite typical, definitely. There is similarly, work-related accidents, which may not make it to court necessarily. A lot of work-related accidents in employment may be settled before they go to court. Okay. Public liability accidents, again, it completely depends. They all happen. A lot of cases are settled, depending on the nature of the case, depending on the kind of plaintiffs and defendants. A lot of companies may not want the publicity of going to court, so they may wish to settle. So,
okay. If I want to know if there is any case related to the road accident and road traffic accident, who involved to settle the case? Police. If there is road accident, if there is case of road accident, road traffic accidents, who involved for solving the cases? Police or who?
Well, if the solicitors are involved, okay. So if you're making a personal injuries claim against the defendant, it is the solicitors who will engage with the solicitor for the defendant, and they'll try to come to a solution, as through that means.
Yes, just for your information, in Nepal, as road traffic accidents is the accident that more frequently it happens. Only two accidents happened as one truck hit to the motorbike and another bus hit to the scooter.
Yeah.
So such road accidents are more frequently happen in Nepal. And only few days ago, I think 2 days ago, as there was one microbus traveling by the narrow road, and then it due to the high speed in the turning, could not control, and then it just plunged into the river, as it's 200 meter down from the road. And still, as that microbus is missing where it's in the river, it's difficult to finding out, and still 11 people are missing. Only as 2 were found dead, and 6 were rescued, but there is very badly injured. So such cases, the road accident cases, we can find more in Nepal than other cases. And if there is any road accident cases, and those cases are led by the police, they lead. The case goes to in the responsibility of the government, means responsibility, and that is led by the police in Nepal.
Well, these are civil cases which I'm talking about today. So they be between the two parties. So it's up to you whether you take personal injuries action against somebody else. You have that option. Okay. Does anyone have any other questions? Okay. So just moving on to damages. Okay. So what damages are you going to claim for in your personal injuries action? So first of all, you have general damages, and this encompasses pain and suffering. Okay. So what is the damage? What is the loss? What's the suffering? You also have special damages, and this will encompass out-of-pocket expenses. Okay, so you could have medical expenses, you could have medical reports, specialist doctor's visits, and you could also have travel expenses. Okay, so these can be claimed for under what's known as special damages. So as I just mentioned there, what's really important in personal injuries actions is the possibility of settlements. Okay, so this is often a one-off sum. Okay, and it would be the solicitor, typically for the defendant, who will say, we want to settle this. So they'll send a letter to the other side, and they'll detail a particular sum in full and final settlement. Okay, so they'll use those words. And these settlements are often without prejudice to liability. Okay, so in offering or in producing a settlement, it's not necessarily indicating that there's liability there. Okay, it's just wishing to settle the matter. So there's huge benefits in terms of settling. Obviously, you have privacy. Okay, the advantage of privacy. You may have a company who doesn't want to go through the court's proceedings. They don't want the media attention. They don't want to be in the newspapers with these particular actions. So for privacy reasons, there's a great benefit or incentive to settle.
And
and
it's
you-
quick.
It's quick. Yeah, of course.
Yeah.
Yeah, you're not going down the court's route. You know, it's beneficial, I think, for all parties involved. You know, one of the other main benefits is the cost implications. Okay, if you're going to continue proceeding with these the court proceedings, you're going to incur further legal costs. Okay, and that's something I think should always at the outset be explained to clients. Is legal fees involved? Because it's often, you know, is it worth it taking a case if it's going to cost you, you know, this much money and you're not guaranteed to win? Yeah. So there's less risk involved with these settlements. So a solicitor should always explain to the client that the preferable way forward with this is by means of settlement as opposed to going to court. And what you might often have heard of cases, you know, settling on the steps of the courthouse. You know, a lot of cases, and I've seen this myself, are settled the day you're going into court, the morning of court. Okay, so they often leave it, you know, till the last minute, and then they say, look, here's the sum we're going to offer this. There may be some negotiating, there may be back and forth, but settlements are certainly, I think, beneficial and advantageous in these type of matters. So some practical points, as I just mentioned there, costs are a really, I think, key issue here. The first thing that a solicitor must do, obviously, when a client has engaged a solicitor, is to send what's known as a Section 68 letter. Has anybody heard of that? Section 68 letter? Basically, this is it's a Section 68 of the Solicitors Amendment Act 1994, and this letter sets out details in relation to legal costs. Okay, so it may set out what the hourly rate of the solicitor involved is, what the hourly rate of whoever else is involved. If it's a medical negligence case, it may set out details of additional medical experts that may need to be engaged. It may also detail barristers' fees and what that's likely to cost. Another practical point, as I mentioned, is the length of time involved. Okay, these cases, they're quite time-consuming. It can take, on average, 2 years at the very least sometimes to proceed with this case through the injuries board, through the courts. So this should be certainly explained to the client from the outset. Also to be aware is that this is often obviously quite a difficult time for the client involved. Okay, it may be traumatic, it may be stressful, it may be causing the client a lot of anxiety, and it's also very costly, as we mentioned, for the client. So just to be aware of this and to explain these details to the client at the outset. Another practical point, and again this is more so relevant for the solicitor who's dealing with the client, is to keep the client up to date. Okay, as I said, the client should have a mirror image of the file that the solicitor has. Everything that's initiated, every communication or correspondence with the other side, with the barrister, with whoever, should be copied to the client. Okay, so they're kept in the loop and they're kept up to date. Also, the risk involved with these cases should always be explained to the client. You know, liability is often very difficult to prove, and there's no guarantee really that the client is going to win. So this obviously needs to be explained.
Yeah, can I ask?
Yeah.
From this point, I found we didn't encourage our client to do something for their benefits, you know?
I know, yeah.
So, are there any legal aid services for some client, legal aid?
Yeah.
Or are there any, because I don't know how much the
Yeah.
client will spend. Because in China, for the civil case, most of the junior lawyer, they will charge the fixed fee according to the lawyer's expertise.
Yeah.
So the client can understand how much they
Yeah.
can spend. But yeah,
Yeah. Look, you will of course.
two questions. Legal aid situation for this
Yeah.
poor client.
Yeah. Well, first of all,
It's costly.
you do have solicitors obviously who are their main interest is billing, right? And getting the legal fees. So legal fees could be, you know, huge, and that's their objective. So they may not want to for example, go down the settlement route, they may want protracted litigation that's going to incur great legal fees for them. So you of course have that. It's not ethically correct, okay, but obviously solicitors are, that is priority. There is legal aid in Ireland, but if you cannot afford a solicitor will be provided to you. It's not open to the entire population and resource restraints, etc. But it is there in Ireland.
So is civil legal aid not highly restrained? Like,
Yes, it is. Yeah, yeah. It's generally for criminal cases that if you cannot afford a solicitor, that they will try to provide.
We have the civil and the criminal law. It's according to the client's income.
Yes. Yeah.
So what can a client do if they don't get a Section 68 letter?
Well, they have to by law. Yeah, the solicitor is required by law to send. That's the first piece of correspondence that should be sent to the client is a Section 68.
And what if it doesn't? If they haven't got it, what can they do?
Well, they should. Obviously they can. There's professional negligence type of actions. Again, they're very difficult to prove, but it would be very unlikely for a solicitor not to send such a letter.
But I need to spend money
Yeah.
for that letter. So
Yeah. Well, you mean that
There's
the
lots of
client-
listers are no win, no fee,
Yeah.
Put it
No
that
phone,
way.
no fee.
Yeah.
Well, there's no.
That's it.
Yeah. Well, you're technically not supposed to do that. To advertise on the basis of no phone, no fee. Is everyone familiar with that term?
in the United States
Yeah.
or in China, we have some case like this.
Yeah.
That is the lawyer will take the risk
Yeah.
because
They
we
will.
thought that if I can win, I
Yeah.
can get some percentage from
Yeah.
the whole remedy.
Yeah.
Yeah.
Yeah, and that does happen. If they don't win, there's
Nothing.
not going to be a fee.
Yeah.
But if they do win,
Yeah.
they'll get
Yeah.
a portion of it.
Yeah.
But they're not technically supposed to kind of advertise along those means. Yeah.
Yeah, here,
sorry.
Yeah.
here I want to know one thing more. If a car driver hit a bicycle, and as the bicycle rider was killed due to that hit, and what types of punishment or penalty to that driver, the car driver?
Who hit the bike? The
Yes, yeah.
cyclist.
Yeah, it's like road accident, suppose, yeah.
Yeah. Well, you mean if he dies, is it?
Yes, yeah.
Well, the option is there for the family to take a case on his, the family of the cyclist.
Okay.
We'd also probably go down the criminal route if it was a dangerous driving, that the state would prosecute the driver.
Okay. Sure. Yes. The driver, for how long he's supposed to be as inside the prison?
Oh, that completely depends.
Okay. But in Nepal, if the driver has a driving license, he's supposed to be in prison for 6 months only,
Yeah.
and he will have to pay as penalty as only 50,000. Yeah, it's for rituals,
Yeah.
and up to 6 months he will be free,
Yeah.
and he will again start to drive.
Yeah.
No problem.
Yeah. I know.
It's
Yeah, sure. I've heard.
increasing.
In Thailand and all in different countries, if you bribe the police, you can get off. It's different in different countries. All sorts of things like that. I might move on quickly because I just want to get through medical negligence. I know that we have 15 minutes left, but we can have questions at the end. But does anyone have any questions at the moment? Any more questions? No? Okay. And also just to mention the MIBI. Has anyone heard of the MIBI? Yeah. It's the Motor Insurers Bureau of Ireland, and you can have a look at their website. It's the MIBI.ie. Basically, the objective of the MIBI is to compensate victims of accidents who have been involved in accidents caused by uninsured and untraced drivers. Okay, and there's a particular procedure that the MIBI provides for. So you can have a look at that if you like on the website. So medical negligence, and just to note that medical negligence, if you're taking a case under medical negligence, it is a form of personal injuries, okay? However, it's quite a specialised, complex area, and it's generally a distinct area to general personal injuries, okay? And again, from a practical perspective, if you are advising a client who has a medical negligence query, it would be advisable to engage a solicitor who is specialised in this particular area, because it's really It's really complex, it's really challenging, it's notoriously difficult to prove a medical negligence case. And again, it's quite protracted, it's quite drawn out, a lot of expert evidence is needed, so it would be advisable to engage a solicitor who's familiar with this area. So what are the common types of medical negligence cases that could come up? You could have injuries caused during a surgical procedure, okay, so that could be an incorrectly carried out operation, it could be an operation where an instrument is left inside the body of the patient. Secondly, you could have failure to correctly diagnose a condition, for example breast cancer. Thirdly, you could have delay in providing treatment to the patient. Fourthly, failure to obtain consent to treatment. Okay, so you may know this from tort. If you touch a patient, if you carry out a procedure on a patient without obtaining consent, you're committing a trespass to that patient. Okay? Failure to warn about the risks of a procedure. Okay, so this is again getting back to informed consent. Okay, the patient should have informed consent of a particular procedure. And finally, prescribing incorrect medication. Okay, so these could all be deemed to be types of medical negligence. Now, similar to personal injuries actions, you have two essential elements, and that is liability and causation. And as I said, it is a really complex area, and there's generally a high threshold for the claimant or for the patient to pass. Okay, so just very briefly, in terms of the different elements. First of all, it's going to be essential to prove that there's a duty of care between the patient and between the medical professional involved. Okay, so generally that won't be your hardest hurdle, because if the patient if they're a patient of the doctor in question, there's an automatic duty of care established there. Okay. Secondly, was the duty of care breached? Okay, so that's the second element that they must prove. Was the duty of care breached? Thirdly, was there damage or loss suffered? Okay. And fourthly, which is perhaps most important,
So relationship.
so fourthly, okay, was the damage or the loss caused by the breach of the duty of care? Okay, so that's the causation element of it. That's going to be the most kind of challenging aspect for the plaintiff. Okay, and some of you may be familiar with the Dunn principles. Is anyone familiar with those? Dunn versus National Maternity Hospital. This is the test that is used by the court in trying to establish whether there is medical negligence. Something else to note is that medical negligence cases are specifically excluded from the remit of the injuries board. Okay, so when personal injuries actions go automatically to the injuries board, it doesn't actually hear or assess medical negligence claims. Something else to be aware of is the time restraints. As I've emphasised, it's important to kind of investigate these quite quickly. 2 years isn't going to be a long time in terms of, you have a lot of medical evidence to gather, you have a lot, of details to kind of gather and put together. So the personal injury summons, it must be served within 2 years of the date of the cause of action, okay, or 2 years of knowledge of the cause of action, okay, and particularly with medical negligence actions, you could very well have a space of time in between when the action occurred and when the patient had knowledge of it, okay. So for example, I don't know, has anyone been familiar with the DLIC hip replacement scandal? Is anyone familiar with that? So this is basically, where faulty hip implants were implanted into patients, okay? And there was approximately a year or 2 years in some cases to when patients had knowledge that they actually had a faulty hip implanted into them, okay? So it's a typical example of the date at which the time begins to run is going to be after the action actually occurred, okay? So that's important in medical negligence cases. Statute of limitations. So procedure, what are the typical steps that need to be taken? Obviously it's going to be critically important to obtain the medical records of the patient. For example, accident and emergency notes, nurses' notes, and drug administration records. Okay, and what is particularly important, I think, in terms of these medical records are going to be the nurses' records. Okay, so nurses' notes. A nurse's role, part of a nurse's role is to document every element of a patient's care. Okay, so the communications between the patient and the doctor, the details of the procedure, timelines with administration of medication, whether the patient understands the patient's general state. So quite often these cases, medical negligence cases, have fallen upon the evidence furnished from nurses. Okay, so just to be aware that that's an important element of evidence. Then it will be necessary to review the records, okay, so to review the various medical records and send to a relevant expert for an expert report as to whether the claim is likely to succeed. Okay, so again, if we're just to take the example of the hip replacement cases, that's obviously you're dealing with orthopedics there. Okay, so it would be necessary for the solicitor to then engage a medical expert in the area of orthopedics to look at the medical records and to assess the particular case. Okay, and also to note here that that is something that's likely to cost in the region of €1,500, €2,000, just simply for that medical report. Okay, so the costs do they do rack up with these type of cases. And often there's need for two experts, okay, depending again on the particular case. Barristers are often engaged at an early stage with these cases. Again, it is quite a specialised area, and again, depending on the complexity of the case, it may be necessary to engage the barrister for an opinion, and then in terms of drafting the relevant pleadings. Some practical points to note. As I mentioned, it is a really complex area, and I would advise that the client in question would need to engage a solicitor who specialises in the particular area. Also to be aware that the client may often be unaware or ignorant as to what occurred. Okay, so particularly in relation to a negligently carried out operation, they may not actually have the details of what actually happened. They may be unsure, they may be confused as to what happened. So just to be aware of that. In relation to medical opinions, practically it's often necessary to look abroad for a medical report. Okay, you may not have a particular consultant living in the area, okay, or even living in the country. So it may be necessary to go, say, to the UK to engage this medical expert and for them to furnish the medical report. These type of cases are often extremely time consuming. Okay, so for example, even waiting for that medical report, you could be waiting months for the medical expert to come back with that report. So these are kind of points that should be relayed to the client in terms of the practicalities of this case. It's also extremely expensive. Medical negligence cases are expensive. In terms of the experts who need to be engaged, in terms of barristers who may need to also come on board, and also the length of time that it may take to go through the courts, etc. So, it's notoriously difficult to prove these cases, and quite often a lot of these cases actually fail. Okay, so they fail on liability issues or liability challenges generally. Okay, so just a few points there on clients with disabilities. I think I would have covered some of these points with you, I think, in the earlier training sessions. So just to obviously be aware that, clients with disabilities, as with any client coming in, has the right to an effective remedy and entitled to be viewed as an equal person before the law. Certain communication and language barriers may be present with certain persons with disabilities, so just be aware of this and be aware when the client comes into you. There may also be certain attitudinal barriers, okay, so making assumptions, having certain negative attitudes as regards, abilities or inabilities of certain clients. There may be information and advice barriers that may come up as well, and from the perspective of the solicitor dealing with the client, they may actually not have a great deal of knowledge about disability and about, the various different elements that they should be aware of. Also physical barriers, okay? There may be issues in relation to access to buildings, access to solicitors' offices, access to courthouses, etc. one final slide here, and it's just on resources and additional information that you can have a look at. First of all is the National Advocacy Service, so just to be aware of that, which was initially set up to provide independent representative advocacy services for people with disabilities. Also, I think citizens' information is always very good for providing some basic advice, so you may want to have a look at Citizens' Information website to see what they have to say, what information is provided. Also, something that I found quite useful when I was training was the Court Service website. Okay, so this is courts.ie, and this has lots of different details in relation to the circuit court, for example, and the different steps involved with, say, a personal injuries action and what steps need to be taken, different templates for the different pleadings, because the circuit court rules has various different requirements. So I think the Court Service website is quite useful. So that's www.courts.ie. Okay, so I leave it there for today. Does anyone have any other questions?
Yeah.
Yeah?
Sorry.
Go on.
It's to do with the informed consent. I can't remember from last year, but there's how much do you have to tell them about the risks? So is it 0.1 of the chance or something?
Yeah, well the general rule, okay, and this does differ according to whether you have both elective procedures and non-elective procedures. Okay, so an elective procedure is, say for example, plastic surgery. Okay, so something that's not an essential kind of emergency type of procedure. So there's a higher risk, there's a higher obligation there to inform of all material relevant risks. Okay, and the general rule is that you must inform the patient of whatever risks and details in relation to the particular procedure, the particular operation, whatever it is, as a reasonable patient would wish to know. Okay, so there's a test there of the reasonable patient. And it is obviously for the court, it's going to go to court, the judge is going to rule upon this, but they generally look at material risks. Okay. Does that answer your question?
Yeah.
Sorry. Did you have a question as well?
Yeah, I was just going to say, if the it's obviously costly to take a lot of these actions, but would it be fair to say that not all solicitors will charge for the original consultation if they want to go get more advice, so you wouldn't want to scare them off too much?
Yeah. Generally, the solicitor won't charge for the initial consultation.
Yeah.
And then the client will go in and they'll
Have a better idea from there.
they'll have a better idea. They'll just take an initial note, as we do with a lot of these clinic sessions. It's initial. This is effectively an initial consultation for the client. They'll take an initial note of the relevant details of the case, and they'll give the client general advice on, look, I really don't think this is, much merit to this to proceed any further with this case. I certainly think you have a case here, and they may say, look, come back, and it kind of will develop from there. Yeah.
Just two questions real quick. I know that the medical negligence doesn't apply to nurses, so does that mean you can go to the personal injuries board? And do you guys have like a list of solicitors who are experienced with working with disabled people? That would be, or would they just go to whatever solicitor?
Yeah. Well, we do have a panel of solicitors who, if a case comes up, and this has happened actually over the last couple of years, if a case comes up that does have merit, we will have the solicitors that we can kind of point them in the right direction.
Right.
Your other question was in relation to the medical negligence cases.
Yeah.
As a general rule, the Personal Injuries Board, or the Injuries Board, doesn't hear any medical negligence cases.
But it doesn't apply to nurses because it's only for professionals, isn't it?
Yeah.
But even then, it's still.
It doesn't, as an area, it doesn't hear medical negligence cases.
So
you proceed directly to court.
Right. Okay.
Yeah, that's what would happen. Like you'd have the initial, the letter.
Yeah.
That
Try
would
to
essentially
settle.
the side trying to call upon the other side to admit liability and to settle the action in advance of going to court. But obviously failing that, there would be kind of proceed to the court.
Okay. Thanks.
Does anyone have any other questions? No?